There's some additional attachments to the plea form.
I saw. Thank you very much. Okay, Mr. Cruz, we did this on Friday. We're going to do this again with regard to case number 18-1958. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Please state your full name for the record.
Nikolas Cruz.
Now, I know you answered these questions on Friday, but I have to ask you again. Are you currently under the influence of any alcohol or illegal drugs?
No, ma'am.
Do you take any medication, or have you started taking any medication since Friday?
No, ma'am.
And you said that you have been perhaps informally diagnosed with depression and anxiety. Did you think of anything else since Friday?
No.
Okay. And are either of those issues disturbing you in any way today?
Yes.
So the depression and anxiety are bothering you today?
Not the depression, just a little anxiety.
Okay. A little anxiety is normal under the circumstances. What I need to know is, are you able to understand me and listen to me when I'm speaking to you?
Yes, ma'am.
And are you able to follow along with your lawyers when they speak to you?
Yes, ma'am.
Are you having any trouble concentrating?
No.
And other than being nervous or anxious, are you having any difficulty understanding anything that's going on here today?
No, I understand what's going on.
Okay. And sir, please, how old are you?
I am 23 years old.
And again, how far did you get in school?
I think 11th grade.
And you do read and write the English language?
Yes, ma'am.
Have you gone over the plea form with your lawyer or
Yes.
lawyers?
Yes, I have, ma'am.
Okay, and did you, I'm going to just go ahead and have you pass this to one of you, please. Yes. And Mr. Cruz, if you would please take a look at this document and let me know if that's the document that you went over with your lawyers, including the addendums, which list counts 18 through 34, along with their minimum and maximum penalty, as well as their minimum mandatories under Florida's 1020 life statute.
Yes, ma'am.
And those are your signatures and your initials?
Yes, ma'am.
Okay, and did you go over each and every one of those pages with your lawyer or with your lawyers, plural?
Yes, I have.
And did your lawyers explain each and every charge to you, as well as the maximum penalty under Florida's 1020 life statute for the attempted murder counts?
Yes, ma'am.
Okay?
Can we just have 1 second, Judge?
Absolutely. Yes, thank you. Okay, sir, you have been charged by indictment with 34 counts, and I'm going to go over those counts with you now. Counts 1 through 17 of the indictment charge you with murder in the first degree. These are life felonies. They are punishable, they're capital felonies, and they are punishable by one of two ways, either life in prison or the death penalty. Do you understand?
Yes, ma'am.
Do you understand that in Florida, life in prison does not carry parole like other states?
I understand.
Do you understand that life in prison means the term of your life? It means you will not come out until you are no longer alive. Do you understand?
Yes, ma'am.
And have you gone over that with your lawyers?
I have.
And do you understand that that is the minimum penalty on counts 1 through 17? In other words, that is the best case scenario for you as a term of the rest of your life in Florida State Prison. Do you understand?
Yes, ma'am.
And do you understand the maximum penalty is death?
Yes, ma'am.
Do you understand that that issue will be left to a jury to decide in a separate trial?
Yes, I do understand.
Do you understand, has anyone made you any promises or guarantees as to what sentence would be imposed if you were to plead to the charges 1 through 17 of murder in the first degree?
No, ma'am.
And when I ask you if anyone's made you any promises or guarantees, I mean your own lawyers as well. Have they made you any promises or guarantees as to what sentence would be imposed, whether it be life or death on counts 1 through 17, by you pleading here today?
No, ma'am.
Now, sir, this is what we would refer to as a strategy decision. In other words, by waiving your right to a jury trial on counts 1 through 17 specifically, you're waiving your right to require that the state prove each and every one of these charges against you beyond and to the exclusion of a reasonable doubt. Do you understand?
I understand.
And do you understand that if the state were unable to prove any of the elements in any of counts 1 through 17, the jury would have to find you not guilty? Do you understand?
I understand.
Do you understand a possibility could be that a jury would find you guilty of a lesser included offense to any of these charges, which may not include a mandatory life sentence at a minimum? Do you understand?
Yes, ma'am.
Do you understand that by pleading to these charges, you are facing a minimum best case scenario of life in prison?
Yes, ma'am.
And have you discussed this strategy with your lawyers?
Yes, I have.
And do you believe that it is in your best interest to enter into a plea to these charges and waive your right to go to trial and require the state to prove these charges against you beyond and to the exclusion of a reasonable doubt?
Yes, ma'am.
And have you gone over the pros and cons of that decision with your lawyers?
Yes, I have.
And have you had enough time to consider both the pros and the cons of your decision?
I have.
Ultimately, it is your decision, and whatever decision you make is fine with me. I'm not here to tell you what decision to make. I'm here to make sure that whatever decision it is that you make is made knowingly, voluntarily, and intelligently, so that you are fully informed and you understand the consequences of your decision. Have you gone over the consequences of this plea here today of guilty with your lawyers?
Yes, ma'am.
And do you understand that you are waiving your right to have the first part of the trial, which is often referred to as the guilt phase, where the jury would find you guilty or not guilty?
I understand.
And do you understand that the state will still have the opportunity to present testimony and evidence against you at what's called phase 2, or the penalty phase of the trial?
Yes, I do understand.
Okay, and you've gone over that with your lawyers in depth, is that correct?
Yes.
Do you have any questions about your decision?
Yes.
You do have a question?
I was wondering if I could say something to the victims.
Okay, well, before you do that, do you have any questions about the rights that you're waiving, or about the decision that you're making, or the strategy decision that you're making with your lawyers as far as pleading today?
No, I understand.
Okay, and you fully had the chance to think about that and to discuss that with your attorneys, is that correct?
Yes, ma'am.
Has anyone threatened or coerced you into entering into this plea today?
No, ma'am.
And sir, have you had ample time or enough time to speak to your lawyers about your plea?
Yes.
And is there anything else you feel your lawyers need to do on your behalf that they have not already done before you enter into your plea today?
No, ma'am.
Sir, do you understand, I've gone over charges 1 through 17. I've told you that they carry a minimum of life in prison and a maximum of the death penalty. Counts 18 through 34 you're charged by indictment with attempted murder in the first degree, and each of those carries a separate penalty, so I'm going to go over those with you now. With regard to count 18, attempted murder in the first degree concerning victim Ashley Baez, you're facing up to a 25-year minimum mandatory prison sentence because the state has alleged that you actually possessed a firearm, that you discharged that firearm, and as a result of said discharge, you inflicted great bodily harm upon Ashley Baez. Do you understand, sir?
Yes, I do.
Do you understand that you're facing between 25 years to life in prison as a maximum penalty?
Yes, ma'am.
And do you understand that the 25-year minimum mandatory prison sentence is a day-for-day sentence under Florida's 1020 life statute?
Yes, ma'am.
Count 19, you're charged with attempted murder in the first degree with regard to victim William Olson. Sir, in that particular charge, the state has alleged that you discharged a firearm, that you possessed a firearm, which means it carries a 20-year minimum mandatory prison sentence under Florida's 1020 life statute, up to and including life in prison. Do you understand?
Yes, ma'am.
Count 20, attempted murder in the first degree with regard to victim Kashava Managapuram. The state is alleging in that count that you discharged a firearm, and as a result of the discharge that you inflicted great bodily harm upon this victim, which carries a 25-year minimum mandatory prison sentence under Florida's 1020 life statute up to and including life in prison. Do you understand?
I understand.
Count 21, attempted murder in the first degree of Justin Colton. That is a 20-year minimum mandatory under Florida's 1020 life statute for the use and possession and discharge of a firearm. Do you understand?
Yes, ma'am.
Count 22 is attempted murder in the first degree regarding victim Alexander Dworet. The state is alleging in that count that you did actually possess, use, and discharge a firearm which carries a 20-year minimum mandatory prison sentence under Florida's 1020 life statute. Do you understand?
I understand, ma'am.
Count 23 is the attempted murder in the first degree of Genesis Valentin. The state is alleging that you actually possessed and discharged a firearm which carries a 20-year minimum mandatory prison sentence under Florida's 1020 life statute. Do you understand?
I understand.
Count 24, the attempted murder of Daniela Menescal. The state is alleging that you actually possessed and discharged a firearm under Florida's 1020 life statute, which carries a 20-year minimum mandatory prison sentence. Do you understand, sir?
Yes, ma'am.
Count 25 is the attempted murder in the first degree of Samantha Grady. The state is alleging that you did actually possess and discharge a firearm when you attempted to murder Samantha Grady, which carries with it a 20-year minimum mandatory prison sentence under Florida's 1020 life statute. Do you understand?
Yes, ma'am.
Sir, count 26 is the attempted murder in the first degree of Samantha Fuentes. In that count, the state is alleging that at the time you did possess, discharge, and inflict great bodily harm upon Samantha Fuentes, which carries with it a 25-year minimum mandatory prison sentence under Florida's 1020 life statute. Do you understand?
Yes, ma'am.
Count 27 is the attempted murder in the first degree of Isabel Checker. The state is alleging that you did possess and discharge a firearm contrary to Florida's 1020 life statute, which imposes a 20-year day-for-day minimum mandatory prison sentence. Do you understand?
Yes, ma'am.
Sir, count 28 is the attempted murder in the first degree of Samantha Mayer. The state is alleging that you did actually possess, use, discharge, and as a result of the discharge, inflict great bodily harm upon Samantha Mayer, contrary to Florida's 1020 life statute, which carries with it on that count a 25-year minimum mandatory prison sentence under Florida's 1020 life statute. Do you understand, sir?
Yes, ma'am.
Count 29, attempted murder in the first degree of Benjamin Wickender. The state is alleging that at the time that you attempted to murder Benjamin Wickender, that you did discharge the firearm and inflict great bodily harm upon Benjamin Wickender, contrary to Florida's 1020 life statute, which in this count carries with it a 25-year minimum mandatory prison sentence under Florida's 1020 life statute. Do you understand, sir?
Yes, ma'am.
Count 30, the attempted murder of Madeleine Wilford. The state is alleging that in this particular count you did possess, use, and discharge a firearm inflicting great bodily harm upon Madeleine Wilford, contrary to Florida's 1020 life statute, which carries on this count a 25-year minimum mandatory prison sentence. Do you understand, sir?
Yes, ma'am.
Count 31 is the attempted murder in the first degree of Marian Kabachenko. The state is alleging that in this particular charge that you did possess and use and shoot a firearm during the commission of this charge, and that you discharged a firearm contrary to Florida's 1020 life statute, which carries with it a 20-year minimum mandatory prison sentence. Do you understand?
Yes, ma'am.
Count 32 is the attempted murder in the first degree of Stacy Lepel. In this count, the state is alleging that you discharged a firearm during the commission of the felony, which carries with it a 20-year minimum mandatory prison sentence. Do you understand, sir?
Yes, ma'am.
Count 33 is the attempted murder in the first degree of Anthony Borges. The state is alleging on this charge that you did actually possess, use, discharge, and as a result of the discharge that you did inflict great bodily harm upon Anthony Borges, contrary to Florida's 1020 life statute, which carries with it a 25-year minimum mandatory prison sentence. Do you understand, sir?
Yes, ma'am.
And finally, in count 34 of the indictment, the state is alleging that you attempted to murder in the first degree Kyle Lamont. and that during that act you did actually possess, discharge, and inflict great bodily harm upon the victim, contrary to Florida's 1020 life statute, which carries with it a 25-year minimum mandatory prison sentence, which is a day-for-day sentence under Florida's 1020 life statute. Do you understand, sir? Sir, do you understand that on counts 1 through 34, by entering into a plea, you are giving up your constitutional right to require that the state prove each and every one of these allegations beyond and to the exclusion of a reasonable doubt?
Yes, ma'am.
Do you understand you're giving up your right to present testimony and evidence or a defense, if you have one, with regard to these charges?
Yes, ma'am.
Do you understand that at trial, sir, your lawyers would have the opportunity to confront and cross-examine each and every one of the state's witnesses who's called to testify against you?
Yes, ma'am.
Do you understand, sir, that at trial you would have the right to remain silent, and that's an absolute right that could not be and would not be held against you in any way whatsoever? However, by entering into a plea to these charges, you are giving up that right. Do you understand?
Yes, ma'am.
Sir, do you understand that you are giving up your right to appeal the judgment and sentence of the court? In other words, if you were to go to trial and you were to be convicted on any of counts 1 through 34, or a lesser included offense of counts 1 through 34, and your lawyers, or you or an appellate lawyer, believe that error was made during the course of the trial, you would be able to appeal the judgment and sentence to a higher court. That's a court that sits in appellate capacity above this court. Do you understand?
Yes, ma'am.
Do you understand, sir, that by entering into a plea, you're waiving that right?
Yes, ma'am.
Do you understand, sir, that if you are found, if you are sentenced to death in this case, that will not be a reason to revisit the strategy here today? In other words, the decision that you and your lawyers have made to plead guilty to these charges, which carry a maximum penalty of death.
Yes, ma'am.
Do you understand that if you're on death row waiting to be sentenced, you can't say, you know what, that wasn't a good strategy. Maybe I should have gone to trial and required the state to prove it. It will be too late at that time. Do you understand?
I understand.
Do you understand that after today, when I accept your plea, you are stuck with your decision and you cannot change it? It will be too late.
I understand.
Do you understand that if you tell your lawyers, you know, put this back on the judge's docket because I changed my mind and I want my phase 1 of the trial, you will not be able to change your mind. You will not be able to make that decision after today. Do you understand?
I do understand.
Do you understand that there have been a number of appellate issues that have gone on throughout the course of this case? Do you understand by entering into a plea you will be waiving your right to appeal those issues to a higher court?
I do understand.
And are you comfortable with the decision that you have made today?
Yes.
Do you feel you've had enough time to speak to your lawyers and to decide whether or not this plea to phase 1 of the guilt phase is in your best interest?
Yes.
And do you believe that decision to be in your best interest?
Yes, ma'am.
Do you have any doubts about that?
No.
Do you need additional time to speak to your lawyers about anything that I've gone over or about your decision to plead guilty to these charges here today?
No, ma'am.
Sir, do you understand all of the constitutional rights that I've gone over with you?
I do.
And do you understand that you're waiving each and every one of these constitutional rights?
I do.
Do you have any questions about any of these rights?
No, ma'am.
Do you wish to waive these rights and enter into a plea today?
Yes.
Sir, do you understand that if you are not a U.S. citizen, you will be subject to deportation under the laws and regulations of the Department of Homeland Security upon entering into this plea?
Yes, ma'am.
Do you understand, sir, that if the offense to which you are pleading is determined to be sexually violent or sexually motivated in any way, or if you've been previously convicted of a sexually violent or sexually motivated offense, this plea may subject you to involuntary commitment under the Jimmy Rice Jessica Lunsford Acts upon completion of your sentence? Do you understand?
I do understand.
State, have you disclosed all items of physical evidence in discovery?
Yes, Your Honor. I must say that, discovery is still going on.
Sure.
In the defense and the state as we go, and it has been, since the beginning of this case.
Okay. To this point, has the defense reviewed all of the discovery in this case with your client?
Yes, Your Honor.
And is either side aware of any physical evidence, if tested, that would exonerate the defendant of any of the 34 charges as charged in the indictment?
The state is not aware of any.
Your Honor, based on the discovery that we have received, we are not aware of any.
Okay, thank you. Okay, does either side believe that there is anything that I need to go over with the defendant that I have not already gone over as far as his plea is concerned? State?
Yes, Your Honor.
Okay.
Just to clarify, counts 18 through 34, the maximum sentence for, the court clearly went over the minimum mandatories that each of those counts carries a maximum sentence of life imprisonment.
Okay, sir, do you understand? I'm sorry if I did not make this clear. Counts 18 through 34, attempted murder in the first degree, carry the minimum mandatory penalties that I went over with you, which were either 20 or 25 years. That's a day-for-day prison sentence under Florida's 1020 life statute. However, they each, in and of themselves, without the 1020 life enhancement, they still carry life in prison. Do you understand?
I do understand.
Okay, Mr. Marcus?
Your Honor, as a result of pleading guilty to these charges, have any promises been made to the defendant by anyone as to what evidence will be admitted or excluded from the penalty phase?
Sir, have any promises been made to you as far as what evidence may or may be presented against you by the state at the penalty phase in this trial?
No, ma'am.
Okay, do you understand that you should, as far as you're concerned, you should go forward with the understanding that everything that could be presented against you can, I'm not saying that it will be or that it is, but you should assume that all of the evidence that was going to be presented against you will be presented against you in phase 2 of the trial, with the exception of any constitutionally excluded evidence, which I don't believe, well, some of the orders that have been signed to this point where that both parties have agreed that a certain evidence would be excluded, that would still be excluded, and perhaps any other constitutionally impermissible evidence that hasn't been decided on yet. But under the rules of evidence, anything else that would be admissible will be admissible for purposes of your understanding this plea going forward at the phase 2. Do you understand?
Yes, ma'am, I do.
Has anyone made you any promises or guarantees that certain evidence would be excluded during phase 2 that may be admitted during phase 1?
No, ma'am.
And do you understand what I mean when I say phase 1 and phase 2?
Yes, I understand.
You've gone over those phases with the lawyers, and I've explained it to you. Phase 1 is what we typically call the guilt phase, where the jury would find you guilty or not guilty, or perhaps guilty of a lesser included offense. And phase 2 will be life in prison, meaning life with no parole. There's no parole in Florida, you understand?
I understand.
Do you understand that in a lot of states, life means life, but in 25 years, they'll consider you for release? Do you understand?
I understand.
But Florida, we do not have that. Life means you are in there for the term of your life, and you do not come out until you are no longer alive. Do you understand?
I understand.
Okay, Mr. Marcus?
One more, Your Honor.
Sure.
And that is, does he understand that all of the attempted murder convictions can be used as an aggravating factor in each of the 17 first-degree murders that will be heard before this jury, and that each of the murders will be an aggravating factor for each murder? In other words, for each murder, there would be 16 additional murders as an aggravating factor and 17 attempted murders.
Okay. So, sir, based upon the state's notice of intent to seek the death penalty, first of all, have you gone over that with your lawyers?
Yes, I have.
And there's actually there's 2 drafts. The second draft, which I believe is the most updated draft, was filed on April 16th of 2018, and it is 3 pages and lists 7 different grounds or aggravators that the state intends to go forth on during the penalty phase. Do you understand?
I do understand.
And do you understand that the felonies that you are pleading to, in other words, I'm going to give you an example. Count 1 of the indictment charges murder in the first degree of Luke Hoyer. By pleading guilty to count 1, the state can use count 1 as an aggravating factor for count 2, murder in the first degree of Martin Duque and Keanu. Do you understand?
Yes, ma'am.
And so forth and so on. And in other words, each count that you are pleading to can be used as an aggravating factor to argue in favor of the death penalty on each of the other counts of murder in the first degree. Do you understand?
I do understand.
And do you understand, sir, that counts 18 through 34, attempted murder in the first degree, can all be used against you as aggravating factors in support of the death penalty on counts 1, 2, 3, 4, through and including 17, individually and collectively. Do you
I
understand?
do.
Mr. Marcus?
That's all, Your Honor.
Okay. Ms. McNeil, do you have anything that you feel I have not gone over, which I should go over with the defendant at this time?
No, Your Honor.
Okay. Mr. Cruz, at this time, do you have any questions?
Yes.
Other than the fact that I believe you want to make a statement, but do you have any questions about the rights that we've gone over, about the penalty phase versus the guilt phase, about any of the specific charges against you, any of the minimum penalties, any of the maximum penalties? Do you have any questions whatsoever about those things?
No, ma'am.
Okay. And is your client waiving a pre-sentence investigation?
Yes, Your Honor.
Can't be waived. So I have to order it. And if the defense doesn't want one?
If it's statutorily required, Judge, at this point, we'll say yes, and if there's any issues, then we'll notify the
Okay,
court.
that sounds good. Thank you. Okay, Mr. Cruz, I'm going to go over each charge with you and ask you how you wish to plea in these matters now, if you don't have any questions.
I do not have any questions.
All right, to count 1 of the indictment, murder in the first degree of victim Luke Hoyer, how do you wish to plead?
Guilty.
To count 2 of the indictment, murder in the first degree of Martin Duque Anchiano, how do you wish to plead?
Guilty.
Count 3 of the indictment, murder in the first degree of Gina Mantalto, how do you wish to plead?
Guilty.
Count 4 of the indictment, murder in the first degree of Alexander Schachter, how do you wish to plead?
Guilty.
Count 5 of the information, murder in the first degree of Elena Petty, how do you wish to plead?
Guilty.
Count 6 of the indictment, murder in the first degree of Alyssa Al-Hadef, how do you wish to plead?
Guilty.
Count 7 of the indictment, the murder in the first degree of Nicholas Dorette, how do you wish to plead?
Guilty.
Count 8, murder in the first degree of Helena Ramsey, how do you wish to plead?
Guilty.
Count 9, murder in the first degree of Christopher Hickson, how do you wish to plead?
Guilty.
Count 10, murder in the first degree of Carmen Shentrup, how do you wish to plead?
Guilty.
Count 11, murder in the first degree of Aaron Feist, how do you wish to plead?
Guilty.
Count 12, murder in the first degree of Scott Beagle, how do you wish to plead?
Guilty.
Count 13, murder in the first degree of Meadow Pollock, how do you wish to plead?
Guilty.
Count 14, murder in the first degree of Kara Loughran, how do you wish to plead?
Guilty.
Count 15, murder in the first degree of Joaquin Oliver Paduay, how do you wish to plead?
Guilty.
Count 16, murder in the first degree of Jamie Gutenberg, how do you wish to plead?
Guilty.
Count 17, murder in the first degree of Peter Wang, how do you wish to plead?
Guilty.
Count 18, attempted murder in the first degree of Ashley Baez, how do you wish to plead?
Guilty.
Count 19, attempted murder in the first degree of William Olson, how do you wish to plead?
Guilty.
Count 20, attempted murder in the first degree of Kashava Managapuram, how do you wish to plead?
Guilty.
Count 21, attempted murder in the first degree of Justin Colton, how do you wish to plead?
Guilty.
Count 22, attempted murder in the first degree of Alexander Dworet, how do you wish to plead?
Guilty.
Count 23, attempted murder in the first degree of Genesis Valentin, how do you wish to plead?
Guilty.
Count 24, attempted murder in the first degree of Daniela Menescal, how do you wish to plead?
Guilty.
Count 25, attempted murder in the first degree of Samantha Grady, how do you wish to plead?
Guilty.
Count 26, attempted murder in the first degree of Samantha Fuentes, how do you wish to plead?
Guilty.
Count 27, attempted murder in the first degree of Isabel Checker, how do you wish to plead?
Guilty.
Count 28, attempted murder in the first degree of Samantha Mayer. How do you wish to plead?
Guilty.
Count 29, attempted murder in the first degree of Benjamin Wickender. How do you wish to plead?
Guilty.
Count 30, attempted murder in the first degree of Madeleine Wilford. How do you wish to plead?
Guilty.
Count 31, attempted murder in the first degree of Marian Kabachenko. How do you wish to plead?
Guilty.
Count 32, attempted murder in the first degree of Stacy Lapel. How do you wish to plead?
Guilty.
Count 33, attempted murder in the first degree of Anthony Borges. How do you wish to plead?
Guilty.
Count 34, attempted murder in the first degree of Kyle Lehman. How do you wish to plead?
Guilty.
I accept your plea of guilty. I find that you are alert and intelligent, that you had made an informed decision with the advice of counsel. I find that you have made this decision after going over and understanding all of your rights, and that you are knowingly, voluntarily, and intelligently waiving each and every one of the rights that I went over with you today. Is the defense stipulating to a factual basis for purposes of the plea?
Yes, Your Honor, we'll stipulate.
State?
We're prepared to make a factual finding.
Okay.
Your Honor, if this case charging the defendant Nikolas Jacob Cruz with 17 counts of first-degree murder and 17 counts of attempted first-degree murder went to trial, the state would be able to prove beyond an exclusion of every reasonable doubt that the defendant committed each and every one of the counts in the indictment, to wit, 17 counts of first-degree murder and 17 counts of attempted first-degree murder. Some of the evidence that would prove that the defendant is guilty of each and every one of the counts in the indictment, but not exclusive, are school surveillance videos, other surveillance videos, witness testimony, witness identifications, DNA, and the defendant's statements, all of which would be incriminating to the defendant. This is just some of the competent evidence that the state would introduce at trial. The whole of that evidence would establish the following facts, Your Honor. On Wednesday, February the 14th, 2018, the defendant, Nikolas Jacob Cruz, contacted Uber and had a driver drive him to Marjorie Stoneman Douglas High School, located at 5901 Pine Island Road in Broward County, Florida. The defendant had with him a rifle bag which contained his Smith & Wesson M&P 15 caliber 5.56 rifle, which is an AR-15 type rifle. He had a backpack that contained a tactical vest that had pockets for firearm magazines. The defendant brought with him to Marjorie Stoneman Douglas 11 firearm magazines. He directed the driver of Uber to drop him off at Pine Island Road in front of the pedestrian gate located on the northeast side of Marjorie Stoneman Douglas High School. The defendant walked through the pedestrian gate and made his way to the 1200 building. The defendant, Nikolas Cruz, had previously attended Marjorie Stoneman Douglas High School. He approached the 1200 building, which is located in the northeast corner of the campus. It is the only three-story building on the campus of Marjorie Stoneman Douglas High School. He entered the east doors of the 1200 building. The 1200 building has 10 classrooms on each floor, 6 classrooms on the north, on the south, and 4 classrooms on the north. That's on each floor of the 34 building, on the three-story building. Upon entering the east doors of the 1200 building, Nikolas Cruz turned right and walked into the east stairwell of the 1200 building. He then proceeded to take out his rifle from the rifle bag and loaded it with one of the magazines. As the defendant was loading the magazine into his rifle, a student walked into the east stairwell, and the defendant said to him, "You better get out of here. Something bad is about to happen." The defendant then entered the hallway at approximately 2:21:33, and he fired his rifle at 4 students who were in the hallway. 3 of the students were in front of classroom 1215 on the south side of the hallway. Gina Montalto was sitting outside the classroom of 1215 working on her computer. Martin Duque Aquilano and Lou Coyer were standing next to her, knocking on the classroom door to gain entrance. Ashley Baez was further west, walking down the hallway towards the west doors. The defendant fired his rifle at Gina Montalto, Martin Duque Aquilano, and Lou Coyer. They were all shot. Ashley Baez was shot in the leg, but she managed to run to classroom 1210 across the hall. Ashley Baez survived her wounds. The defendant then turned and fired into the classroom window door of classroom 1216 on the north side of the hallway. He then knelt down in the hallway, took off his backpack, pulled out his tactical vest, put the vest on, loaded another magazine, and he crossed the hallway to the south side of the hallway once again to classroom 1215 and 1214, which are both adjoining classrooms. He again fired into Gina Montalto, Martin Duque Aquilano, and Lou Coyer. Gina Montalto, 14 years old, who was sitting in the hallway in front of classroom 1215, was shot 4 times and died of her wounds. Martin Duque Aquilano, 14 years old, was shot 8 times and he died of his wounds. Lou Coyer, 15 years old, was shot twice and he died of his wounds. The defendant then began firing through the glass window again into 1214. Then he went across the hall, placed another firearm magazine in his rifle, returned to 1214 and fired once again into classroom 1214. 6 of the students in classroom 1214 were shot. Helena Ramsey, 17 years old, was shot 4 times and she died of her wounds. Nicholas Dorette, 17 years old, was shot 3 times and Nicholas died of his wounds. Isabel Checker, Danielle Menescule, Samantha Grady, Samantha Fuentes were wounded, but they survived their wounds. The defendant then walked east in the hallway and once again fired through the classroom window door of classroom 1216. He shot 8 students in classroom 1216. Alex Schachter, 14 years old, was shot twice and he died of his wounds. Elena Petty, 14 years old, was shot 4 times and she died of her wounds. Alessa Alfadef was shot 8 times and she died of her wounds. William Olson, Justin Colton, Genesis Valentin, Alexander Durrett, and Keshava Magaporium were wounded, but they survived their wounds. The defendant went back across again to 1214, and he fired into 1214 once again. As he was doing that, Coach Christopher Hickson opened the west doors of the first floor hallway and ran in to see what was happening. The defendant fired his rifle at Christopher Hickson, hitting him twice. Christopher Hickson, wounded, crawled across the hallway and hid in one of the alcoves on the north side of the hallway. The defendant then walked up to classroom 1213 on the north side of the first floor hallway and fired through the glass door in the glass in the classroom door. Carmen Shentrup, 16 years old, was shot 3 times and she died of her wounds. Madeleine Wilford was shot multiple times, but she survived. Samantha Mayer was shot multiple times. She survived. And Benjamin Wickander was shot multiple times, but he survived. The defendant then continued west down the first floor hallway, and as he passed Christopher Hickson, who was hiding in the alcove, he fired once again into Christopher Hickson. Coach Hickson was shot 3 times, and he died of his wounds. The defendant then entered the west stairwell, and as he entered the west stairwell, there is a door to the west stairwell. And coming in through the door in the west stairwell, which was Coach Aaron Feiss. As Coach Aaron Feiss opened the door, the defendant fired twice into Coach Feiss, who fell by the west stairwell door. Coach Feiss died of his wounds. The defendant then went up the west stairwell and entered the second floor hallway. As he went down the hallway, he fired into classroom 1231, which was empty, which was on the north side of the hallway. He then crossed the hallway and fired to classroom 1234. It's on the south side of the hallway. That classroom was also empty. He then walked up to the east stairwell, and he walked up the stairs. Due to the percussion from the defendant firing his rifle, the dust from the ceiling tiles caused the fire alarm system to sense smoke, causing the fire alarm to sound. Because the fire alarm was sounding, the students and the teachers were evacuating their classrooms due to the fire alarm sounding. The defendant, upon reaching the third floor, as he exited the stairwell, he fired into Scott Beagle, who was a classroom teacher in 1256. Scott Beagle was shot 4 times, and Scott Beagle died of his wounds. The defendant then fired at another teacher, Stacy Lapel, who was out in the hallway with Scott Beagle. She was wounded, but she survived her wounds. She was a classroom teacher in classroom 1255. As the students and teachers were running back to their classrooms, the defendant placed another magazine into his rifle and proceeded to fire. He shot Meadow Pollock, who was hiding in an alcove of classroom 1249, along with Carol Longren, as they hid in that alcove. The defendant then shot down the hall Anthony Borges multiple times. Anthony Borges survived his wounds. Marion Kabachenko was shot, but he survived his wounds. Kyle Lehman was shot, and he survived his wound. The defendant continued to fire as he moved down the hallway, shooting Meadow Pollock, Carol Longren, Joaquim Oliver Padoy, Peter Wang, and Jamie Guttenberg. The defendant continued further west in the hallway, and as he approached Meadow Pollock and Carol Longren, who were still in the hallway, lying on the floor in the alcove of 1249, fired into them once again. Meadow Pollock, 18 years old, was shot 6 times, and she died of her wounds. Carol Longren, 14 years old, was shot 3 times and died of her wounds. The defendant then approached the alcove of the men's bathroom on the north side of the hall. Lying wounded on the floor in front of the men's bathroom door was Joaquim Oliver Padoy. The defendant once again fired into Joaquim Oliver Padoy. Joaquim Oliver Padoy was 17 years old. He was shot 4 times, and he died of his wounds. The defendant then approached Peter Wang, who was wounded and laying just outside the hallway of the west stairwell. Peter Wang was 14 years old. He was shot 12 times, and he died of his wounds. Jamie Guttenberg, 14 years old, as she was running down the hall, she was able to reach the door on the west side of the hallway. She was shot, and she died of her wounds. The defendant then entered the teacher's lounge, which is on 1240, it was at the north side of the hallway. And he fired 5 rounds outside the west window. The window overlooks a courtyard in the parking lot. He then turned and fired out of a south window that looks over a courtyard. He fired 10 shots in total. He then ran out of 1240 and went into the west stairwell, took off his vest that still contained 5 firearm magazines. He laid his gun down, and he ran out of down the stairs and out of the 1200 building on the west side, and he left the 1200 building at 2:27:55 p.m. He then ran and blended in with students who were evacuating the campus due to the fire alarm. As he walked away into a residential neighborhood, he was arrested at 3:49 p.m., approximately 3 miles away from Marjorie Stoneman Douglas High School. There are the facts, Your Honor, that we would like on the record as a factual basis for the plea.
Okay. Based upon the stipulation as well as the factual basis presented by the state, I do find there's a factual basis for the plea. And based upon the defendant's guilty plea, I am going to adjudicate him guilty of counts 1 through 34 of the indictment. Also, a matter that was not was placed on the record but not in the defendant's presence, is that I did adjudicate the defendant guilty of all 4 counts of the information in case This was done on Friday. In case number 18-14129, I did on Friday, which was the October 15th, I adjudicated defendant guilty of count 1, attempted aggravated battery on a law enforcement officer, count 2, battery on a law enforcement officer, count 3, depriving an officer means of protection, and count 4 of the information. The defendant was adjudicated guilty. Now that he has been adjudicated guilty, I intend to set the homicide case for trial on the sentencing phase 2 trial. Before I go ahead and discuss that part, is there anything else that either side wishes to add to the record or present at this time?
I believe Mr. Cruz wanted to make a statement to the court and to the victims present in the
Yes.
courtroom.
Okay.
May I take off my mask?
Sure.
I am very sorry for what I did, and I have to live with it every day. And that if I were to get a second chance, I will do everything in my power to try to help others. And I am doing this for you, and I do not care if you do not believe me. And I love you, and I know you don't believe me, but I have to live with this every day. And it brings me nightmares, and I can't live with myself sometimes. But I try to push through because I know that's what you guys would want me to do. I hate drugs, and I believe this country would do better if everyone would stop smoking marijuana and doing all these drugs and causing racism and violence out in the streets. I'm sorry, and I can't even watch TV anymore. And I'm trying my best to maintain my composure, and I just want you to know I'm really sorry. And I hope you give me a chance to try to help others. If I believe it's your decision to decide where I go and whether I live or die. Not the jury's. I believe it's your decision. I'm sorry.
Okay, anything else?
Nothing to say, Your Honor.
Judge, at this point, I don't think there's anything stopping the court from sentencing him on the 18-14129 case to 25 years concurrently, Judge. There's nothing to stop the court from doing that.
I'm sorry.
That asks the court to impose the sentence of count 1 of 15 years Florida State Prison, count 2 consecutive 5 years Florida State Prison, count 3 consecutive 5 years in Florida State Prison, and count 4 is a misdemeanor, Judge. That asks the court to sentence him now.
I don't think the victim is here for the purpose of the sentencing for that.
The victim has decided he does not want to be present. He asked me to ask Your Honor to impose the maximum sentence as possible.
I don't believe legally I can impose a consecutive, counts 1 and 2 are the same.
Well, they're not, Judge. They have different elements, and we do believe that you can sentence him to consecutive sentences. So we would ask for 15 years, which is the maximum on count 1, 5 years consecutive, which is the maximum on count 2, 5 years consecutive to that, which is the maximum on count 3, followed by a year, which is consecutive to that, which is the maximum on count 4.
So even though count 2 is a lesser included of count 1, you believe legally I can impose consecutive sentences on 1 and 2?
It is actually not a lesser included.
Factually, Judge, they're separate offenses.
Because one is an attempted aggravated battery on a law enforcement officer using an item as a blunt object, whereas the second one is battery on a law enforcement officer, which is based on the punching and hitting.
Okay.
So they are separate offenses.
Are you in agreement that I should impose the sentence at this time?
Yes, Your Honor, we are. We would ask, it's a total of 26 years in Florida State Prison. We would ask that you adjudicate him. You've already found him guilty, and that you impose that sentence.
Judge, if I may interrupt for a minute.
Sure.
And that is when the defendant was exercising allocution, he said at the very end that he believed that you were in charge of his sentence and not the jury. So,
I'm not sure if he was talking about, I'm not exactly sure who he was talking about. I don't know if he meant you meaning me or you meaning the
but if we can
victims.
clarify so that he does understand that in Florida, it is going to be a jury that determines his sentence as to counts 1 through 17 and not this court. So that we don't have an issue later on appeal or a 3.850 or a 3.851 saying that he misunderstood.
Sure. Mr. Cruz, I'm not sure who you were, I'm not sure if you were talking to me or the victims' families when you said you. But you do understand the state of the law. I went over that with you.
Yes, I do.
And so you know that it's neither me nor the victims' families that are going to be in charge of imposing the death penalty. I don't know if you meant, the way I took it was you meant that they could ask the state to waive it. No, that's not what you meant. Well, why don't you just tell me what you meant?
What I meant was is that I believe they should have the right to choose the victims themselves on whether I should take life or death.
So in other words, you're urging the victims to encourage the state to waive it and
No.
sentence you to life.
Judge, may I interject?
Sure.
I think what Mr. Cruz was saying was that ultimately, in his heart, he believes it should be the victims' families that make the decision about life or death. We have, however, explained to Mr. Cruz that it will in fact be the jury that will make that decision after the presentation of evidence of aggravators and mitigators in Phase 2.
Okay.
This, I believe, is just his personal belief.
I understand.
It is in conflict with the law, but he understands the law.
Okay.
Yeah, I
Mr.
understand.
Cruz, is that correct?
Yes.
So if you were the legislature, you would leave it up to the victims to decide what penalty to impose, but you understand that's not the state of the law in Florida.
Yes, I understand that.
You understand it's going to be up to the jury.
I understand that.
Okay.
Thank you, Your Honor.
Sure. Okay, the court having adjudicated defendant guilty, the defendant having waived PSI, the state is indicating that the victim in case number 18 14129 CF10A, which is Sergeant Raymond Beltran, has waived his right to be present before the court today. Is there any legal reason why I should not impose a sentence at this time?
No.
No, ma'am.
On count 1, attempted aggravated battery on a law enforcement officer, I'm going to adjudicate, I have adjudicated you guilty. I'm imposing a period of 15 years, Florida State Prison, with credit for, I believe his credit on the 15th was 1,034 days.
I wrote it on the plea form, Judge. I don't have it on me.
That would have been Friday, but so,
I'm sorry?
a couple of days.
1, 3, 5. With credit for 1,345 days time served. Count 2, battery on a law enforcement officer. The defendant has been adjudicated guilty. I'm imposing a sentence of 5 years Florida State Prison to run consecutive to count 1. Count 3, the defendant has been adjudicated of depriving an officer means of protection. I'm going to sentence you to 5 years Florida State Prison to run consecutive to counts 1 and 2. Finally, count 4, the defendant has been adjudicated of attempted use of a self-defense weapon against a law enforcement officer. I'm imposing the maximum sentence of 364 days in the county jail. That is to run consecutive to counts 1, 2, and 3. Each count is to run consecutive to one another. I'm also imposing all mandatory court costs, costs of prosecution, fee for court-appointed counsel, and pursuant to 943-325, the defendant is required to submit to 2 samples of his blood or less intrusive method for purposes of the DNA bank. Sir, you have 30 days to appeal the judgment and sentence of the court. Your failure to file an appeal within 30 days or contest the imposition of the public defender fees would waive your right to contest those fees and or to appeal the sentence and judgment of the court. Do you understand?
I do understand.
You are to be given credit for 1,345 days time served. However, the defendant is to remain in the custody of the Broward County Jail and is not to be remanded to the Department of Corrections until the completion of Phase 2, which is the death penalty trial in the 181958 CF10A. Thank you.
Yes.
Judge, we would request that as to count 18 through 34, which are not counts that are eligible for the death penalty, that the court impose a sentence of life consecutive to each count at this point so that the victim's family have some closures as to those counts and understand that Mr. Cruz will not be leaving the Department of Corrections until he dies or if he is in fact sentenced to death on counts 1 through 17.
Your Honor, all the victims are not here for those counts, and they have a right to be heard, and many of them want to be heard.
Okay.
And I'm in agreement with that, Your Honor. Can we just set it for a separate sentencing hearing on counts 17 through 34 so those victims can in fact be heard?
I mean, my inclination would be to do it at the same time so that we don't have to have everybody come back here more than necessary. State, do you have a position on?
Yeah, I think that your idea is a good one.
Because then we have to have two separate.
No, I understand the court's position. We just wanted, for those families on count 17 through 34, I'm sorry, 18 through 34, have some closure on those counts, and the community can start healing knowing that Mr. Cruz will never leave the Department of Corrections. But I understand the court's position.
I think by you making that statement that's on the record, and hopefully that message will be conveyed, your intention will be conveyed to them. All right, now.
Can we just have a few minutes before we proceed to scheduling?
Absolutely. We'll take how about a 15-minute recess? Does that work?
Yes, thank you.
Okay, thank you.
You've been listening to one of the deadliest shootings in American history, and Nikolas Cruz, the accused shooter, the shooter who has admitted to these murders and attempted murders, saying in front of all of the families of the victims, South Florida, around the world, that he is guilty, and speaking out to those families saying he's sorry. And this was a poignant and really troubling time for everybody to watch, trying to put an end to the misery that those families have been dealing with for more than 3 years now. But to hear him say guilty to every single charge, premeditated murder and attempted murder, 34 counts, and you see all those family members crying, holding back tears, and listening to the words of Nikolas Cruz as we see those faces that we have lost. And it really was just such a moment for all of us. This is really not even the end, but This is the beginning of the end.
Crushing to listen to the Chief Prosecutor, Mike Satz, walk us through the state's evidence of the horrific crimes that happened that day, and Nikolas Cruz admitting to murdering 17 people, 14 innocent children, 3 adult heroes, admitting to trying to murder 17 more. You saw those families overcome with emotion as he said guilty, overcome with pain as the judge read the names of each one of those children or adults who were murdered in school that day, more than 3 years ago on that Valentine's Day. And in that statement, he did apologize, but he also talked about hating drugs and that he can't watch TV, and he asked the decision on what should happen to him to come down to the victims' families. Now, he also acknowledged, as referenced to by his attorneys, by the defense team, that he cannot make that kind of decision, and that is up to a jury of 12 people that will be seated in the months to come. A disjointed statement by Nikolas Cruz in referring all sorts of different things, saying that he's having trouble living with himself, and certainly the families of those victims, seeing them there in the courtroom, it was just crushing. And this is not justice for them. That may be to come as we wait to see what happens next.
Yeah, we've already seen that the counts 1 through 4 on the battery of a law enforcement officer and the details that go along with that, taking his weapon and using his weapon. The judge has already sentenced him to almost 26 years in prison with the credit of the time that's already served. But now we are talking about a sentencing phase that will come with the second phase of the trial. That's the penalty phase. He has waived his rights to the guilty phase, phase 1 of the trial. And so now we'll go into the penalty phase, and that's where a jury will be seated through the rest of this year, possibly the trial beginning in January. That is going to be a hard trial to seat, as you can imagine. Just like watching this hearing was so emotional and just so painful for all of us who have lived through this, especially watching the victims of the family, the members of those families that have lost their children, lost their loved ones, was so emotional. And now it begins in the months ahead. Although albeit it is a shorter phase that we will see that will take place now that we have taken out at least a few months of that guilty phase. And just a mention, because we will be going to Cristina Vasquez in just a second, but the judge spent a long time, an extra long time, making sure that Nikolas Cruz knew what he was admitting to, what rights he was waiving, what he was saying he was guilty to. She went through each and every aspect of that very slowly and very meticulously, surgically making sure she checked to see if he has depression or anxiety. He said some anxiety. She said that's okay, that's normal, but also making sure, and she went on to say he's alert, he's intelligent, he's making informed decisions, he knows all of his rights, and he is waiving them. So this was where we got to see all of that happening, which is the legal aspect of it. And then when he made a statement, you were wondering what he was going to say to these families. It was very rushed. It was kind of a strange rambling,
Yes.
Confusion as to who he was talking to. The judge thought he was talking to her, but he was actually talking to the families of the people that he has murdered and attempted to murder. But now we are going to see what lies ahead. And at this moment, this is where a lot of the details get a little bit legalese and a little bit inside the nature of the courtroom. And so we do have Cristina Vasquez standing by in a courtroom right next door. And even down to the last second, Cristina, we even saw that the defense with Nikolas Cruz was still trying to say, can we go ahead and deal with the attempted murder counts, the 18 through 34, just so that they could give the families some justice and some closure today, even down to that last second right before they took that 15-minute recess.
And I think we could all really feel the weight of this moment for the community, for the families of the victims. This has been years to get to that point that we all just bore witness to. As the judge accepts Nikolas Cruz and his defense team pleading guilty to the total number of 34 charges against that 17. That is the murder in the first degree. Those are for the students and staff who lost their lives on that day. And then you have the 18 to 34, those last 17 counts. And those are the folks who were hurt. And as he goes step by step, right, as the judge reads the count and the name associated with the victim's name and he says guilty, that whole process is, you feel the weight of that moment. But when the lead prosecutor then outlines for the record the facts of the case, down to the moment he arrived and indicating for all of us those victims, right, because behind charges and counts are people and the families and the community's lives who have been shattered at their loss. And he walks you through where they were in the school, where he was, Nikolas Cruz, based on surveillance video and witness testimony, and outlines it to the very end. And even some details that were just gripping to the heart, you know, including one of the victims lying wounded in front of a man's bathroom and really outlining this idea of an execution style sort of moment there. And so as we now, the judge has accepted this and we all sort of witnessed that kind of harrowing, chilling outline of events. You could see family members there tearing up and crying. We are now stepping into what's called the penalty phase. So for a death penalty case like this one, after the guilty phase, which is essentially what just happened, right? Instead of a trial, we have him pleading directly to the court. This now steps us right into the penalty phase. That is when a 12-member jury will have to unanimously decide on death if that's their choice, but that's where a 12-member jury will then be tasked with making a legal distinction, a moral choice, doing this weighing of should Nikolas Cruz pay for the crimes he committed with his life. And now joining me is legal analyst David Bogenschutz. He's a criminal defense attorney and a former prosecutor. And you and I were looking a little bit at the families, right, and the reactions as that moment was happening, as a lead prosecutor is laying down the facts of the case, with those families in mind, with the community in mind who's watching this unfold. When we get to the penalty phase, as you've explained it, it's a mini trial. We heard that talked about today. There'll be some evidence presented. Do the victims' families have an opportunity at that moment to make statements?
Sure. They have an opportunity to make statements under what's called victim impact. They have to have at least one aggravating circumstance proven before that victim impact becomes appropriate. But I think what we saw here today is that we had black and white admissions made by the defendant as to at least 34 aggravating circumstances. The factual issues that we saw here today are the epitome of cold, calculated premeditation. That's one of those aggravators as well. Heinous, atrocious, and cruel, another aggravator. Many people jeopardized with their lives, another aggravator. Those aggravators are going to jump up and just overwhelm this jury, I believe. I don't know of a series of mitigating circumstances that are going to come close to being more important than those aggravators.
Well, it's interesting you say that, because I was thinking when then Nikolas Cruz says he wants to make a statement to the victims, he starts by apologizing. It seems to then go a little rambling, it appears, a little off track about talking about marijuana and drugs, and then he sort of reverts back. I was curious to get, from your experience, is one of the reasons why they wanted that moment to happen, where Nikolas Cruz addresses the victim families now, in order to leverage that in the penalty phase, when the defense says a mitigating factor is, look, he's taken responsibility for it, he even apologized the day he pled directly to the court. Would that be one of the reasons why there was sort of a speaking moment for Nikolas Cruz today?
Well, I think they could raise that, frankly, but I mean, I think it's pretty transparent. And I think it was bizarre. I mean, it was a bizarre statement. I would think that looking at that statement, one would be thinking about his mental state. And I think that that's a continuing factor that this defense is going to have to link to these crimes to show it's still continuing. It may not be continuing for purposes of actually entering the plea and understanding that. But for his overall view of this incident, to suddenly launch into things like marijuana and drugs when it's not even an element here, an issue here, frankly makes me question where his head is really at. And as I said, I think that's going to be the linchpin of any defense that they have in the death penalty, and that's the mental state of the defendant at the time that looks like it's continuing today, if this has any bearing or any intelligence at all.
Which is of note and interest, because there has been this thought that perhaps the defense would intend as a mitigating factor to talk about his state of mind at the time. You're even looking at what he just delivered right now, right, with the question about his mental awareness capacity. But yet we saw just on Friday, when Nikolas Cruz and the defense team came to this judge and pled guilty on the 4 counts related to the battery on a law enforcement officer case. That was that 2018 caught on camera BSO jail guard attack.
Right.
When she was setting up, ensuring that he was, met competency and the kind of standard questions, she had asked him about any past physical mental illness, and he responded with, in the past, I've had anxiety and depression, to which she countered any official diagnosis. He says no. And then we get into today, that moment is truncated a little bit because they have that on the record. And then she asks it again, and he basically says, do you think your depression that you have mentioned you have is affecting, okay, maybe it's just nerves. When you take that with the statement he just made, how is the defense then going into the penalty phase making this argument in terms of his state of mind, to try to convince a jury to spare his life?
Well, I think their spin on this, if that's the right word, has got to be that he was talking about his current mental issues and not necessarily what he may have not even realized back in 2018 when this incident took place he was suffering from. I think that it's harmful. I mean, it certainly is harmful. It would be harmful if I was dealing with this, and that's something that the defense is going to have to try to move the jury's thoughts away from and look at him as he stood in that hallway at Marjorie Stoneman Douglas, firing at individuals who he didn't know, in order to utilize that defense. And it's got to be an extreme mental. The statute says extreme mental issues, not just the fact that today you got up and you felt bad. I think the most chilling thing to me, and the thing that if I were a parent would make me even more emotional than they already were is to think of a child on the floor dying, or at least virtually dying,
yes.
and having somebody walk over with a cold and calculating act
Yes.
to end their lives as they lay there helpless. To me, that was the thing that gave the chills to me. And I don't know how you get over that. I just don't.
Agreed. In that moment, which you heard me articulate, just walking folks through, it was that portrayal and his descriptive language setting up that scene, and you could really be there. That was him laying down facts, and you could feel it in just a few minutes. Now we're the penalty phase, for folks to be really clear, it's like a mini trial, as you've described it. And so, you know, from your experience, what do you think the jurors going to be receiving in terms of that little bit of window, those 4 minutes? They're going to be getting the actual evidence, correct? They're going to see the surveillance video. They're going to hear witness testimony, correct?
They should be, and because in order, even though we already have multiple aggravating factors that have been admitted to in terms of the other charges, when we get into things like cold, calculated, premeditated, that's one. Mm-hmm. Heinous, atrocious, and cruel, that's another. The state's going to show evidence of that. And one of the things that we just discussed is a, to use the same word again, a linchpin of that kind of evidence. Committing a homicide where the person has already been shot, suffering, and the action of just going over and attempting to kill that person, attempting to commit a murder, not just shooting at people and having them fall on the ground, but walking over and making sure they were dead. That's horrifying. And this is a tough call for the defense in this case. I don't care how problematic his mental issues were at the time. Those kinds of facts, and I think very well played by Mr. Satz, an experienced and a good prosecutor, are going to be difficult to overcome. They just really are.
I know some community members had reached out to me, and we flushed out a little bit with your expertise about why the defense would take perhaps this tactic, right, the strategy decision to forego the guilty phase, an actual jury trial for that, and just plead directly to the court. Do you think that we all just got a real window into what underpins it? Because if the couple minutes of him laying out just facts of the case could be felt so, it was palpable, it was visceral, do you think perhaps the defense thought, you know what, let's mitigate against the amount of evidence and witness testimony that the same jury that has to decide whether he lives or dies, let's mitigate against exposing them to all of that during the guilty phase and then again in the penalty phase?
I think that's exactly what went on here, and I think that it was calculated on part of the defense to try to eliminate as much of that as possible. But you know, in normal criminal cases, if you waive and accept and waive any kind of presentation of evidence but agree that there's enough there to take the plea, that stops it. I don't think Mike Satz was going to stand for that. I think that Mike did what he does best, and that is told the community, this is what I'm dealing with here. This is what happened in this case. And no matter how many times you try to waive that, the state still has the right to present that evidence. And I think it was very effective. I mean, I think it was very effective.
When we get into the penalty phase, one thing, unlike the guilty phase, is that the penalty phase is also evidence about the character of the person.
Right, that's in the victim impact for more than anything else. You have to have that one aggravating circumstance, which I think we're far past that at this point in order to get to the victim impact. And I mean, the lives of these children and the individuals who are adults, who were not only made problematic but also ended on that day. I think that those kinds of things almost are going to be window dressing to describe what kind of children these were, what kind of men and women these were.
I see.
Because once we get to that point, this jury is going to be inundated with the kind of shocking and horrific evidence that you heard today, but firsthand, not just from a lawyer talking about it and going through it as much as he could without a lot of emotion. But the testimony in this case and showing physical.
Okay, you've been listening to Christina Vasquez talking with J. David Bogenschutz, and we will resume our coverage with them and analyzing some of the details of what you saw today. On the left side of your screen, you see some of the families of the victims talking in the courtroom after Nikolas Cruz admitted his guilt to the 17 murders and the 17 attempted murders on that awful day in Parkland back in February of 2018. On the right side of your screen, you have some of the surviving victims there. That is Anthony Borges, who was shot and did survive that shooting. He is speaking with family members and his attorney. Let's listen to that briefly.
What do I think? It's not a problem. He did his decision, so he's facing it right now. I'm gonna do it with my life. I'm just gonna keep going. Play soccer again. That's it.
He says he apologizes. Do you accept an apology?
I'll say it, but like, to be honest, it's not my problem. That's his decision.
Everybody take their own decision, you know? Right. What should happen to him? What is the punishment appropriate?
I'm not God to say that.
Anthony, when you were hearing him pleading guilty to those charges, what was going on in your mind at that time?
Nothing. To be honest, nothing.
Do you talk about?
You have a question?
Yeah.
Sensitive?
Is there a sense of justicia? Is there a sense of justice for you hearing him say guilty when your name was read on that count?
When I hear my name, to be honest, I feel like kind of like emotional things happening, but like, to be honest, that's his decision. He did the decision like to shoot everybody.
Anthony, what do you want to come out of this? What changed? You know, I know there's so many things that you mentioned with the system that went wrong for this to happen. What do you want out of this? What do you think the next step is to make sure these things don't happen?
That's actually the most important part that he's talked about, is that the most important thing that can come out of this, that nothing like this ever happens again, that the school board and DSO make the changes so you don't let somebody loose, like you don't turn somebody loose like Nikolas Cruz on innocent children in school, and they don't know that. So, you know, we're at this point we're coming close to the end. The schools have made changes, so you know, it looks like it's in the process. Obviously, this will help much in the healing process for Anthony, so that's really where we're at. He's forgiven him, he's moving on, and he hopes that there's enough adjustments to be made that this never happens again.
And you're his dad?
I'm his lawyer.
His lawyer. Tell me your first and last name.
Alex Ariaza.
Can you describe the emotion A-R-I-A-C-A. Thank you so much. I appreciate it.
It's really hard as a parent. It's really hard. I can compare myself, you know, with the other parents because Anthony's still here. So my mission is, as a parent of the victim, and he's alive, fight for him. That is my, my decision, and that is my right to do it.
Anthony, can I ask you, because I'm sorry, you're facing the other way. Tell me again, what was it like being in the same room with Nikolas Cruz, seeing him walk into the room? And also, do you believe him when he said, I'm sorry for what I've done?
I didn't feel scared. He's a human, I'm a human too. He took his decision to shoot the school. That's for everybody. He took his decision to do it. Now he's facing it. That's not my right. Like, I'm not God to take the decision like to kill him or not. That's not my decision. My decision is to be a better person and be like to change the world. And every kid, like, I don't want nobody to like happen this again. Like, it hurts. It hurts. It really hurts. So like, stop. That's it, and just keep going. That's it.
Para terminar nada más tus sentimientos como padre al entrar al cuarto, ver a Nikolas Cruz, estar ahí junto a tu hijo. ¿Nos puedes decir eso en español ya para dejarlos en inglés?
We've been listening to Anthony Borges, his father, and his attorney speaking out. This is one of the surviving victims of the Parkland massacre, but also one of the surviving victims, the only surviving victim that was not included in the $25 million settlement with the Broward School District, and that was just settled this week over the handling of Cruz. 52 people killed, injured, or traumatized in the shooting have reached that settlement, but Anthony Borges was not included. He was a little tight-lipped in his feelings in front of the microphone right there, but he said he wants to be a better person and change the world. He didn't have a lot of comments about that decision and being left out of the settlement, at least not what we heard right here. But the reporters there asked him how he felt seeing Cruz in the courtroom. He said he wasn't scared, and he was repeatedly asked how he felt about Cruz's statement to the families of the victims and those who have lost their loved ones. And he said he's a human just like I'm a human, and I'm not God. He said he definitely did not want to give an opinion on whether Cruz should live or die based on his actions on that February 14th day.
Anthony Borges very clearly making it about himself. He said he will not cast that sort of judgment and weigh in on an opinion of what Cruz's sentence should be. He's going to focus his energies on making himself a better person. We've heard that statement before from Nikolas Cruz, described by J. David Bogenschutz, our legal expert here, as bizarre. Let's listen in to what Nikolas Cruz had to say when he was given the chance to speak to the families of the victims that were there in the courtroom listening to his guilty plea.
I am very sorry for what I did, and I have to live with it every day. And that if I were to get a second chance, I will do everything in my power to try to help others. And I am doing this for you, and I do not care if you do not believe me. And I love you, and I know you don't believe me, but I have to live with this every day. And it brings me nightmares, and I can't live with myself sometimes, but I try to push through because I know that's what you guys would want me to do. I hate drugs, and I believe this country would do better if everyone would stop smoking marijuana and doing all these drugs and causing racism and violence out in the streets. I'm sorry, and I can't even watch TV anymore. And I'm trying my best to maintain my composure, and I just want you to know I'm really sorry. And I hope you give me a chance to try to help others. If I believe it's your decision to decide where I go and whether I live or die. Not the jury's. I believe it's your decision. I'm sorry.
And just for clarity, because it was unclear not only to those who were watching it live, but even to the judge, when he was saying you, he was speaking directly to the victims' families. And the judge made it very clear that he needed to understand that it's not up to the victims' families on whether he lives the rest of his life in prison or whether he dies. That is up to a jury of 12 of his peers here in South Florida. And so once that was clear, it became obvious that his intention was to try and alleviate somehow some of the immense pain that those families were feeling sitting in that courtroom. And so that was the basis of the statement. And whether or not what you heard from him weighs into how they'll move forward from the defense process in the sentencing phase of this trial certainly plays a factor, because it's hard to see and clearly get an idea of what Nikolas Cruz is thinking and how they'll use that as they prepare what is called the mitigating factors. That's what the defense team will use to try and present mitigating factors in an effort to spare his life when we get to that sentencing phase of the trial.
Well, it certainly was an odd statement. It was a strange rambling, and there was that confusion because the judge said, wait, you know, I'm not in charge of your fate. And then the defense spoke up, his team standing right next to him. The defense spoke up and said, no, this is just his wish. He was telling the victims' families that he wished they could decide whether he spends life in prison or whether he receives the death penalty in Florida. Again, life in prison with no parole based on our state statutes. So that's what was clarified. But even when we listen to him talk about drugs, marijuana, TV, a chance to help others, you are wondering about his mental state. And I know the victims' families sitting there, I don't know if they wanted to hear anything, if anything out of Cruz's mouth helps at all, probably not. But hearing him say that, you still are thinking, I know he says to the judge that he's aware of his actions, but between the mental state of what he did 3 years ago and the mental state today in court, it certainly brings up question as to where he's at. And then, of course, we have the attack on the law enforcement officer that happened not too long after being put in jail. So you're thinking, where is he at in his actions and his statements? I know he was hoping to give some closure, something to those families to let them understand where he was coming from, but it certainly didn't do that. Like I said, I don't think anything he could say could necessarily do that. But this has always come up, that this was a troubled person his whole entire life, all kinds of issues, which is why we had that settlement with the school district, but that he had issues and things that flared up and things where the police could have been more involved, the FBI could have checked out more of the tips that they were given. All of these things came up throughout his life that we knew we had a troubled person all along. And then what happened on that fateful day with the mass murder. And now you're seeing him in his own flesh, in his own words, saying his last piece, and still you wonder where his thought process lies.
And you certainly wonder what the defense is thinking as they prepare to move into this next section, this next phase of the process here, this penalty phase of what will be a trial in the weeks or months to come. Let's get back to Christina Vasquez and J. David Bogenschutz to delve a little bit more deeply into this issue, because Christina, after that rambling and bizarre statement, the methodical facts of the case that Mike Satz, the former Broward State Attorney, but is still the chief prosecutor of this case, he laid those out in chilling and graphic and heartbreaking detail. And so you get to the point where the state has made it clear they have more than enough facts to present a strong death penalty case. If you are the defense, what kind of mitigators can you argue? Can you use what you saw today? Do you put Nikolas Cruz on the stand?
And it was indeed harrowing. Chilling is another word you have used, as the lead prosecutor, laid out the facts of the case with that descriptive language and placing the victims in the different areas in the school and walking you through what they have learned from witness testimony and surveillance video from the time he arrived, Nikolas Cruz, to the time that he was arrested. But I'll actually pick up from something you were all just discussing, which is when Cruz is speaking, that statement he wanted to give to the victims, and you had all discussed just now a little bit of what appeared to be maybe confusion with the judge. Perhaps more it was the judge trying to clarify that when Cruz says you should decide whether to get life or death, in that moment, that with his defense team clarifying that it was an interpretation of his desire that the victims perhaps do that. And with that, I bring in now David Bogenschutz, criminal defense attorney and former prosecutor. And when we get to that moment where there's this interpretation, right, and the defense team kind of on his behalf says, no, what he meant is conceptually, I guess, he would like the victims. But this will be the task of members of our community. There will be a jury selection process coming up for the penalty phase, where folks in our community will have to make this decision on life and death. How long? We know that the judge has said about 15 days for that jury selection process, in part because it's expected to be a challenge finding 12 fair and impartial jurors. What do you expect when we get to that moment for the defense to be asking during jury selection as they try, from their perspective, to find someone who could be fair and impartial to Nikolas Cruz?
Well, I think they're probably going to do more of divining exactly what type of juror they want for their defense, because the facts on this are, to say the least, chilling. So you're going to have to get people on this jury that understand what mental illness is and what mental illness might do, because even though they may put on evidence of it, there are people that just debunk it and say, look, this is too horrible, I can't deal with it. So if I'm doing this, I sit there and I start trying to find out people who believe in mental illness, because that's the only defense they have here, the only defense. And how much of a background they may have in mental illness, whether they have family members that have
okay, we're going to have these two continue to have a conversation.
Yes.
Let's get you back inside the courtroom. Judge Elizabeth Scherer has brought all the participants back into the room.
At 9 o'clock, reporting for a scheduling conference and status conference. That's the day that the motion to suppress was originally scheduled. And then at that time, you all can tell me which motions are moot, which are agreed upon, which need to be revisited based upon the change in circumstances with regard to the Phase 1 trial.
The defense is agreeable to that.
Okay. And then the only other, I guess I'll call it a housekeeping matter that the state pointed out is that, Mr. Cruz, you are still under oath. I did not go over the score sheet with you based on the fact that the maximum sentence and the minimum sentence, it doesn't really apply, because I told you the minimum is life and the maximum is death. However, in the abundance of caution, the state wants me to let you know, and your lawyers agree, that you score 92.5625 years Florida State Prison at the bottom of the guidelines. However, based upon the mandatory penalties as they pertain to your specific charges, your minimum is life in prison instead of 92.5625 years up to death. And I think that's it. State, are you satisfied?
Yes, Your Honor.
Okay. And I did sign the score sheet and it's in the court file. Oh, you can have it. I already signed. Sure. Thank you. Okay, so you can have a seat. So as far as today is concerned, I believe that's everything, and I will see you all on the 26th, which is Tuesday, at 9 a.m. for a status conference. We will be back in 7750. Judge Williams allowed us to use his courtrooms today because it was supposed to be a trial, so we just kept the plea in here, but we'll be back in 7750 for the pretrial issues.
Just so that, because I know there's a lot of interested parties, the court had indicated before about a November beginning the penalty phase, and if you could just comment.
Sure. Based upon the information that was provided to me by both the defense and the state, we are going to begin jury selection for the penalty phase on Monday, January 4th. The lawyers are going to utilize we have motions scheduled the last week of October, and the lawyers are going to utilize November and December, which are what I call sort of choppy months, because, for example, the courthouse in November is closed on the 11th, the 25th, and the 26th, which makes at least 2 of the 4 weeks very short weeks where we don't have juries. And then the week of December, the month of December, the courthouse is closed the 24th and the 31st. So based on those sort of limited weeks, the lawyers are going to take advantage of those November and December to finish up all of the penalty phase related motions, related depositions, related preparation, and then we are going to be starting again January 4th with jury selection. If you all can please be prepared on the 26th to let me know any preliminary plans that you have as far as jury selection. I think based upon we will be able to utilize this courtroom so we can we can fit more people. However, based upon the limited amount of questioning that the court did in the other trial, it seems like 200 to 250 are the maximum amount of people, even with very limited questioning, that we can get through per day, as opposed to the jury room had like over 500 for us one day for the last trial. I don't think that's necessary, because I don't think there's any way we can get through more than, based on my experience with the other trial, even though this is not the same, even if it's very preliminary, I think 200 to 250 per day would be the maximum. Does anyone disagree with that number? No. Okay. So when I have them start issuing the juror summons, I'm going to have them keep that in mind, because I hate to have 300 extra people waiting around all day to be questioned when there's absolutely no way we can get to that many per day. So we'll try to have at least 200 per day for pre-jury selection to go through, and we'll start that on January 4th. Other than that, I'll see you all on the 26th.
Thank you.
Yes.
Are we deferring what constitutes pre-selection till another date?
Yes, that's what I wanted to discuss in part on the 26th. And if you all, because you all were going to have...
We have come to agreement on some of those issues.
That would be great.
We'll revisit them
and
on
I know
Friday.
it's not going to be the same as the other trial, because obviously there's other issues that need to be addressed. But I was saying, just taking the other trial just as an example, with my very limited you know, announcement of the charges and so on and so forth. Just to get that many bodies in, even assuming we can take 50-something at a time, I don't know how we can get through more than 4 groups in a day. I think Mr. Ehrman would probably agree with that, okay?
There's just some other issues that
Sure.
you may be able to
No,
move
absolutely,
forward.
absolutely. So we'll discuss all of that on the 26th. I'll see you all at 9, and we're in recess.
Thank you.
Thank you.
Judge Scherer just recessed this hearing that we've been sitting and watching in awe and wonder, and it has been an emotional day. We are reliving what happened more than 3 years ago here in South Florida, but it affected the whole world and changed so many things and brought about so many activists and people hopeful to change gun laws and spur on gun reform. But today was about everybody you're looking at right here, the victims' families, hearing from Nikolas Cruz as he pled guilty to 34 charges, as he waived his rights to a jury trial, as he understood from that judge that in the minimum situation, he is in prison for the rest of his life, the maximum situation, which has always been what the state has gone after, what the state attorney, the prosecution has gone after, which is the death penalty, which in our state is the maximum penalty. That minimum penalty, life in prison, which is what Nikolas Cruz is hoping to get to by pleading out to these crimes, is no parole. And she said to him repeatedly over and over in the courtroom today during this hearing, this plea hearing, that you're never getting out of jail. You know you'll be in prison for the rest of your life. There is no going back. There is no appeal. There is no change. And that was something that was made very, very firm and made sure that he understands what he's doing. She asked him repeated questions about that.
The judge was very thorough. They're leaving no window of opportunity for any misunderstanding in what Nikolas Cruz did today. So we will see them again October 26th, our understanding, for a pre-trial hearing on figuring out the preliminary logistics of the jury selection process. November and December, as we know, there are many days where the court system is closed because of the holidays, so that means jury selection will begin officially on Monday, January 4th. And as you can see, this has all been about the victims on the screen right here. We scrolled through their pictures, these 17 young people, the 14 children, the 3 adults who tragically lost their lives that day. This is about finding justice for them. In a chilling way, Nikolas Cruz admitting that guilt today in front of those families, in front of the world. You saw it right here on Local 10, and we have so many more aspects of what will come to delve into, and that's why we have our team coverage this morning.
Because it gets very detailed with the legal aspects of this, even as you've been following this case, and you know that he's a confessed murderer from back in 2018, on video with his own cell phone, on video with police in the courtroom today, but it's not that simple. It delves much deeper. So we know that we have just fast forwarded through phase 1 of the trial. That's the guilty phase in his pleading guilty to 34 counts that was happening today. Now phase 2 of the trial, which now won't start till 2022 and still should take months, although not as long because we've cut this trial in half. These are the details that we will still have to go through, and those poor families still have to watch, and they will still relive these moments. Today was so hard listening to the state walk us through the timeline again. And so this is far from over, but we are halfway through. So in some ways, that is the justice that was served today, and that is the closure that was received today. But we're going to go back to Christina Vasquez because court has adjourned, so we do know court is over, so we'll be able to talk to you without any interruptions right now. So that has brought us to where we're going to be, and now we're fast forwarding into next year, and then we will be in the penalty phase, the sentencing phase, the jurors who decide Nikolas Cruz's fate. And this basically boils down to 2 factors, life in prison or the death penalty.
So this will be a 12-member jury that has to make that ultimate decision, right? They have to hear the evidence and that harrowing witness testimony. They're going to hear from the defense saying they're mitigating factors. The defense is going to say, consider all of that, but also consider, and they perhaps may bring up the age that he was at the time, his state of mind at the time. You're going to have, these jurors are going to hear from the state talking about aggravating factors, of which prior convictions are one of them. And now he has a whole bunch of them, correct? We have what happened today. We happened last week where the judge accepted his plea for the 4 counts related to the battering the law enforcement officer. They're going to say that. They're going to talk about the nature of the crime, right? And they're going to walk through what you heard that lead prosecutor do in that gripping way, where you also see that premeditation. And then the jurors will have to consume all of that and make the ultimate decision on whether or not Nikolas Cruz should pay for these crimes with his life. And therefore, when we get into jury selection, which the judge just said will start in January, we do expect just that initial jury selection process to take quite some time. And joining me now again is David Bogenschutz, criminal defense attorney and former prosecutor. How long do you, from your experience, when you're seating what you have called a death jury, right, a death panel jury of 12 that has to make this legal choice, a moral choice, how many weeks do you anticipate that process to go?
It's indeterminate. I mean, it's going to be weeks and weeks, if not months, because now you're dealing with the seminal issue that most people are thinking about in this case and have thought about. I don't think anybody has ever taken a position that Nikolas Cruz wasn't guilty of this. The only issue from day one has been, what's the penalty? And when you're dealing with life and death, people have you have different views about this as a person looking inside as you do have a person looking outside. So I'm guessing we probably will have to set aside 1,500 jurors, because it'll go in stages. The first stage will be not necessarily what you know about the case, but whether you can sit as a juror for some period of time that's definitive. Immediately you'll lose people on that, especially after the first of the year.
Which is interesting, because one thing you had predicted, originally the judge had said last week that she thought maybe the jury selection for this penalty phase on this case would start in November, and you had actually predicted it may not, because November, December holidays would be very difficult beyond everything else we're talking about just to get folks to commit to that section. It's going to start in January, and then when they move into that process, for the defense and the state, you're going to get to the moment, what you just talked about, the initial just pre-screening, right? Can you do this? What are some hardships? But then you get into actual, where you have a smaller pool, and they get a chance to question the jurors.
Right.
So on this case, first, give me the prosecutor's hat and the defense hat, maybe in a sentence or two, succinctly. For the state, what kind of line of questioning should we expect you hear them asking the jurors if they try to find someone, and then the same for the defense?
I think the more important question is what their issue is on the death penalty when you're death qualifying a jury in a case like this, because you have a younger person sitting in there. You have, I mean, just facially, what they're having to deal with is Nikolas Cruz doesn't look like a monster. He just doesn't. He looks like a young kid. He sounds a little weird. That's because of the things that he said. That may be because of his illness, but whatever. So the prosecutors just kind of want people that are able to keep an open mind about the death penalty, are willing to vote for the death penalty if they feel it's appropriate. And that's why I think, with the prosecutor's standpoint, is you put as much information in as you can. If you're seeking the death penalty, you don't cut corners. You put everything in, every nuance, every little drop of blood, everything you can think of to cause the juror to be literally horrified into believing this is the kind of sentence that's appropriate.
But when we're in that section where they're beginning to question potential prospective jurors, now you're the defense. What's your line of questioning as you're kind of eyeing community members? And remember, we have the prosecution's obviously trying to make that argument that the jurors choose death unanimously, but the defense is trying to convince folks to spare his life. So as you're looking at prospective jurors and the defense team, what are you looking for? What line of questioning?
I'm looking for people who are ambivalent about the death penalty. I'm looking for people who have mental health backgrounds or are familiar with mental health issues and mental health awareness. You need one, that's all. The prosecutor needs 12.
But let's drill down on this mental health issue again. You have obviously what happened that day at Parkland. Then you have 9 months after the Parkland shooting is when we see that surveillance video coming out of BSO, right, where there's that jail guard attack. So the prosecution would have that. Look, and then even after he was incarcerated, look what happens 9 months later. Now you have some statements on the record between last week and then this critical statement on the record today. So when Cruz decides that he wants to make what he described as a statement to the victims, I think going in, most folks would have anticipated it might include an apology, but then he diverts, right? It seems to be a little stream of consciousness. He talks about marijuana and drugs. That doesn't seem to have any relevancy. He even has a inward-looking comment, right? It's supposed to be a statement to the victims, and here are family members whose lives have completely been shattered. For the rest of their lives, they will live with the loss of that day, and then they hear the man who just said he's guilty for doing it say, and I can't watch TV anymore. How does that all play for the defense in terms of they're trying to now, in this next stage, convince a jury to go
outside the courtroom?
Believe in the death penalty.
What are you hoping for the sentencing?
As I was just saying, we are. This is my son Tom. We are hoping for the death penalty. So, and he did. Oh yeah, you want to say something?
I mean, my mom covered a lot of it. You know, my reaction to his attempted apology was, you know, for lack of better words, tell him to go shove it. Thank you. Like I was saying, yeah, if he truly felt any remorse about what he did, he would have thought about what he was about to do before he did it. He had up until, you know, he called that Uber or when he was getting out of that Uber to decide that this wasn't the right thing to do, and he still chose to go through with it anyways. So any apologies he has are essentially hollow to us, and they don't really mean anything. And that's why, you know, we're hoping for the death penalty, because, you know, that's the best way that, you know, he will hopefully actually feel some bit of remorse or some bit of what we had to go through and what our loved ones went through.
And I'm sure it was very tough hearing the details of what exactly happened. Did you already know all of those? Did they already talk to you about that?
Yes. Tom and I actually watched the video of the shooting. We did that last year because we didn't want in the public to be the first place that we watched it. And for us, you know, the story about Chris hasn't been accurate. And I think after today and hearing how all of that went, people will understand he truly did run in that building with every intention. He did stop the shooter from continuing to shoot in one room. And for us, we know that Christopher, we wish that it had been the end of that shooting spree, but we do know that he saved lives. And it just, for people to be able to understand that when we already knew it is a little bit of comfort. And so people understand why it's so important to us to remember those victims, because Christopher wasn't just shot. He ran in that building to try to save lives, and ultimately he saved some. I wish he had saved more. That's one of the things, but it's so important to us because that's what matters. That's what matters.
Yeah.
Thank you. Anything else you wanted to say?
Emotional reaction.
I guess the only other thing on that part that we're talking about, you know, the story of my dad and why, you know, we definitely feel for the death penalty. You know, just in my dad's case alone, Mike Satz was talking about how, you know, my dad ran in, he was initially hit, and then he sought shelter, and then, you know, the shooter came by and then essentially executed him. So, again, he showed no remorse. He had the chance to just walk right past my dad, and my dad might have had the chance to survive. But because he decided to commit that act, that right there alone for me solidifies why the death penalty is so important. Thank you.
Thank you both.
The Hickson family leaving the courthouse today, reacting to Nikolas Cruz's guilty plea, reacting to the decision that will be now in the hands of a Florida jury on whether or not he will serve life in prison or receive the death penalty. We're going to continue to wait and see if we hear from any more family members who are exiting the court today. Saw some really emotional reactions after the guilty plea, and certainly as the chief prosecutor Mike Satz was walking us through what happened that day in that excruciating detail, and you heard it there echoed by those family members. They lost loved ones in a cold and calculated way, a way that seemed to have absolutely no remorse in it, despite the apology that Nikolas Cruz offered today. Those family members did not accept that in many cases, and they are choosing to focus on the sacrifices that their loved ones paid that day. You heard there Deborah Hickson, who is currently a Broward School Board member, describing her husband, Chris, who was the athletics director there, going into that building because he knew something was wrong, going in there to try and stop that shooter, and going in there and paying with his life in the slightest effort to try and save other people's lives. And that is the heroism that we're going to be hearing from many of the victims' families through their grief and through their pain and through their anger as this process plays out. Because beginning in January is when jury selection begins, and then when that trial begins and that jury is seated, we're going to have to hear, and those family members are going to have to hear, those gruesome and graphic details as the state makes out its death penalty case against Nikolas Cruz.
And today, since it was all about Cruz and his pleading guilty to these 34 counts, she said straight to the camera, remember, my husband's a hero. He saved lives. You've been listening to Nikolas Cruz all day, but remember what happened that day. And you do know that she became a school board member so that she could make change here in Broward County in South Florida after her husband's death. And she said, this is why I want the death penalty. And it's interesting to note that every family feels different. Of the 17 families who lost their loved ones that day, some want the death penalty, some want Cruz to suffer in prison for life. And we're watching as more family members come out. And of course, if any of them speak to Local 10 and our cameras, we will bring that to you.
This is the defense team for Nikolas Cruz. We've seen many family members come out. We'll see if the defense team here decides to stop and speak. It does not appear that they are going to do that. They spoke in court. He shook his head no as reporters asked him if he has anything to say. That was the lead prosecutor for the Nikolas Cruz defense team, David Wheeler, who shook his head no. And so we're going to continue again to watch and monitor this situation as family members of those who died, of some of the surviving victims, continue to leave the courtroom today. And if we hear anything, if any of them decide to stop and speak and share their thoughts on the guilty plea and on what should happen next, we will certainly bring that to you live. We'll do that all throughout the day here at Local 10.
Yeah, we've already heard from Joaquin Oliver's father, Manuel. He said not even the death penalty would in any way balance what happened to my son. And we do know Andrew Pollock. These are some of the outspoken family members. He had his daughter, Meadow, who was killed in that mass shooting. He said, get him out of the jail and put him in the prison where he gets prison justice. There's so many raw feelings and emotion that are happening now, reliving what happened 3.5 years ago. Right now, you're looking at video of what we've been watching. This was actually from Friday. This was when we heard Cruz speak out after he was facing those counts and pleading guilty to battery on a law enforcement officer. And that's when we heard him tell the judge for the first time that he did not think that he was suffering from any mental illness issues, but he admitted that people have accused him of that before. And that is certainly something that's going to come up as we deal with the penalty phase of the trial, because you would have to imagine that the defense would be focusing and honing in on mental illness as they plead their case. And they're hoping what they get for Cruz is life in prison. They're trying to avoid the death penalty in the state of Florida for Cruz. That has always been their case. That has been their case since 2018, but never was a deal made with the prosecution. The state attorney always stood by, we are seeking the death penalty, and he's never wavered on that, even as he stepped down as state attorney and he's gone to lead prosecution. And we heard him go through the timeline today of exactly what happened on February 14th. Never once has he said anything other than they are seeking the death penalty for this mass murder situation.
And it certainly plays into the idea from the other side that never was the guilt of Nikolas Cruz in question. More family members here leaving the courthouse. Let's see if anyone decides to stop and speak with reporters. No, there was so much emotion here inside the courtroom. Let's listen in for a moment.
You just tell us, obviously, we know that today was a hard day. Tell me kind of how are you feeling after what's happened?
Well, we're feeling very disturbed. It was a difficult day to have to relive the day of the shooting and hear a few details about what happened to our daughter at the hands of this cold, calculating murderer who today admitted to murdering 17 people and his desire to murder another 17. He's a violent young man.
We saw you shaking your head about the emotional thing when he did speak and address the victim. What was your thoughts on that?
Well, quite frankly, we were very surprised to hear him speak, and really have no interest in what he said. If he wanted to do something for our families, he shouldn't have killed our loved ones. Let's just make that clear.
What are you hoping for the sentencing?
Well, I think that as a society, we should prosecute the people who commit these heinous acts to the fullest extent of the law. We need to find a way to prevent others from wanting to copy them. We need to have you in the press help reduce his notoriety as much as possible, so we don't have others who want to follow his terrible and painful path. We also need you to help us remember the victims, the vibrant and wonderful people that they were. And finally, we ask that everyone join together to help prevent these attacks. If you have a concern about a student who might need some help, speak up. Let's get them the help they need before they resort to violence and destroy families and communities. We miss our daughter Gina every day. Thanks.
Parents of Gina Montalto. Gina was 14 years old, a freshman, a Girl Scout, in the color guard. Was a soccer player. Let's listen in as someone else decides to speak and share their experience here today.
Yes, I wear these every day, and my coworker just gave me this new necklace to wear for Luke. But Luke's fund on it is the Luke Hoyer Athletic Fund, and all of his proceeds are donated to foster kids in Broward County to help them with their athletic equipment. So we're very proud of his fund.
What did you think about what he had to say?
I didn't care to hear what he had to say. I was really shocked that he was able to speak. It was very uncomfortable because what he had to say to me was it's going to be a strategic move for the defense to use later. He has no remorse. This is all a show, theatrics from him. He planned my son's murder and 16 others and attempted murder. He is an evil, evil young man, and we hope that the death penalty is the end result. For me, life in prison, that is a life. Luke doesn't get any kind of life. Life in prison, he still gets to have a life, get married, have a family. He deserves to be on death row, and the death penalty needs to be served on him. I hear all the time that he has issues. No, there's a difference between having mental problems. Evil is evil. But to me, this is Ted Bundy evil, and there's nothing that's going to satisfy me but the death penalty.
How hard was it when the state was laying? You heard those?
Yes, because we have sat in many Marjorie Stoneman Douglas School Safety Commission hearings, so we've heard all this, so we know. It's hard to hear it repeated. I know exactly where Luke was when he was murdered. It's hard to think of him just walking back to class with his friend, standing in front of our now dear friends, Jennifer and Tony Montalto. Knowing that they were just standing in the hall having a carefree day, and then they get viciously murdered. You know, people don't really know that he came back and would shoot everybody again. So he is a very violent, evil young man. People have to remember that. And as Tony mentioned, we do want y'all to remember the sweet souls of who we lost that day. They were all very generous, loving children. We have 3 amazing a teacher and 2 coaches that were amazing or missed by their families. But we want them to be remembered for their good, how sweet they were. They were taken from us way too early, and we miss them terribly. Thank you. Thank you.
gut-wrenching to hear from these families, their raw emotions, their memories of that day. We're watching a courtroom hearing today, and we're watching Cruz plead guilty, but these families are reminding us of everything they experienced on the day when they lost their loved ones. That was the family of Luke Hoyer. They called Luke their precious child. He was only 15 years old, and she just said right there, he just was in the hallway enjoying his day, happy-go-lucky, not a care in the world. And now he's gone, and she wanted to remind everyone about what their family has experienced by losing their child, their family member, and she's not the only family. We've seen so many family members, and she, like others, have said, I want the death penalty because I want justice, and I don't want him to live out his life in prison. Really powerful and poignant to hear straight from people's mouths who've experienced the loss of that mass murder saying, no, I don't want him to live another day.
Saying, I don't have my child or I don't have my loved one. They are no longer living. And so the ones that we have spoken to, you have heard from, have expressed their desire to see the death penalty implemented by the jury in this case. Again, you heard there from Gina Hoyer. We also heard from the Montalto family. Those two families were sitting in the same aisle during this hearing, and we saw a lot of emotion from them, holding hands, gripping each other, tears streaming down their faces. And even after those guilty pleas, it seemed like that real camaraderie born from pain grew inside that room as now all of these families try and process what happens next. They have to also prepare for what the coming months will bring as the next phase begins. We also heard both families here say they have absolutely no interest in what Nikolas Cruz had to say, that they thought it was strange that he had an opportunity to speak, and that his words mean nothing, and his apology to them, and paraphrasing here, meant nothing. If he was truly sorry, he never would have opened fire on that day. If there was any real remorse in his heart, it would have been cycling back to the opportunity not to have killed their loved one. So visceral pain, you see it right here, and it is heartbreaking because these are our community members, these are our neighbors, these are friends of many of us here in the community, and so watching them relive this all together is just so hard to do, but it is an important part of the process because it has been 3+ years coming as this process and what eventually will be a sentencing trial will begin in the next couple of months.
Yes, and just to go over the details, we do know, because we had anticipated possibly that jury selection would begin this year with the trial taking place in January, but that has since changed. Obviously, we are about to head into the holidays, and just a reminder, if you're tuning in right now to Local 10, we do know that there will be pre-jury selection and a lot of prep going on at the end of October, November, and December, and jury selection in the penalty phase of this trial, the second part of the trial, will begin Monday, January 4th. You can only imagine these families spending their time in the holidays waiting to see what happens next, but the big thing that will be the decision factor in the whole entire part of this trial will be the 12 jurors who will be seated, and they will hear from both sides, the defense as well as the state prosecution, about whether or not Nikolas Cruz should receive the death penalty or whether he should receive life in prison. Remember, there are 17 capital felonies for the murder 1 counts, and then there are 17 attempted murder counts. Minimum penalty, life in prison, maximum penalty, death by lethal injection. So this is what we are hearing from these families about what they feel. And we haven't heard from every single family, but it has been really emotional, gut-wrenching, just true, raw feelings, hearing from the families who say, you took my child's life, your life should be taken too.
We have crews spread out all across the area getting reaction. Let's check in one more time briefly with Christina Vasquez, who is in an adjoining courtroom, to wrap up our coverage on what she saw there.
And what is of interest is, as we've heard those family members of the victims in this horrifying case come and approach and speak, they were asked a question again about that statement that Nikolas Cruz made. He said, he told the judge he wanted to speak to the victims, but in that moment, in the context of what he was saying, we hear him go on that tangent, bringing in now, again, our legal analyst for today, David. And one thing that you and I were discussing is, you know, we hear him speak about the marijuana marijuana and the drugs that seem not to be relevant. For families whose lives were shattered, they're listening to him talk about things like he can't see TV anymore. This is recorded. So do we think that what just happened today, would either side actually play that for the 12-member jury that will be deciding whether he pays with his life for these crimes during the penalty phase? Is what we just saw could be evidence in that next phase?
Sure it could. It could be brought in if the defense comes in and, as we expect they will, and puts on evidence of his mental state at the time and, you know, whether or not that should be considered by the jury. I think the state is eminently able to come in and say, well, let's see what he looked like at the time that he should have been the most penitent. He should have been the most emotional when he sat there and virtually in a kind of a cold and calculated way said the things that he did say.
Just minutes away on Local 10 News at noon, a guilty plea on 17 counts of murder and 17 counts of attempted murder by Nikolas Cruz in a Broward County courtroom today.
We have everything on local10.com, but stay right here for continuing coverage right now. Your Local 10 News at noon is next.
Floridians are fighting back.
We are coming together to do our part.
Getting a vaccine can not only protect you,
but your loved ones too.
It's easy. It's safe.
It's effective.
It doesn't matter where you live
or what you do for a living.
If you're eligible to receive the vaccine,
there's a vaccine available for you.
As we get back to normal,
let's do this together.
Leon Health, your new Medicare Advantage plan, offers up to $1,200 for covered over-the-counter products. For more information, call Leon Health today, 305-541-LEON.
I drop off and pick up my kids from school, so I can't work early or late. And I need to make enough to make it worthwhile.
I can only work 2 days a week, and it can't interfere with my other job.
I can do full-time, just not daytime, and I need benefits. Good ones.
And you know, it'd be nice if you paid for my tuition, like all of it.
I grew up here, played ball here with my dad. As the first Miami-born mayor of our city, I've known these courts, these neighborhoods my whole life. But it's not just places, it's people that make Miami. They're why, as mayor, I've worked to create new jobs and help seniors with a rental assistance program, and why I'm running for re-election on November 2nd, to keep working for you, because every corner counts and deserves to thrive.
Leon Health, your new Medicare Advantage plan, offers zero copay on comprehensive dental care, including implants, crowns, and more. For more information, call Leon Health today, 305-541-LEON.
It is unconscionable that we live in the world's richest nation and many can't afford quality health care. Medicare for All will be one of my main priorities. As CEO of a healthcare company, I'm uniquely qualified to advocate for the passage of this legislation. Healthcare should be a human right, and I will work hard for its passage. To learn more, go to peoplesprosperityplan.com. I'm Sheila Sherfilis McCormick, Democrat for Congress, and I approve this message.
The doctors and staff at Clinical Care Medical Centers pride themselves in knowing what is best for every individual and their unique health. Thanks to years of experience, our trusted team can provide patients with complete, high-quality medical care in a warm, family environment. And now, with over 25 medical centers, clinical care is every day closer to you. It is our priority to ensure you receive the exceptional care you deserve, so you can continue making memories with those you treasure. We make the difference.
I am very sorry for what I did, and I have to live with it every day. And that if I were to get a second chance, I will do everything in my power to try to help others. And I am doing this for you.
And we